This second discussion area for discussion 7 part 2 is about trying to balance prisoners' rights and then also the need for punishment in corrections. And I've done quite a little bit of research on this. I actually have about this much information, and then I've been working on it. I've even had a couple of assistants helping me try to get it better organized. I really came down to a couple things, and I'm just, because these video lectures have to be so short, I'm just going to refer you to a couple things that you can look at on your own. One of them is the Fordham Urban Law Journal, which is about prisoners' rights to physical and mental health care, modern expansion of the Eighth Amendment cruel and unusual punishment law, and it's by Stuart Klein, K-L-E-I-N. It's a 1978 Law Review article, Volume 7, Issue 1, and so it's interesting and very meaningful and kind of a precursor to what I'm going to talk about now, which is the Jailhouse Lawyer's Manual, that was actually prepared as kind of a white paper by the New York Law School, and so in a sense it's a kind of a law review oriented type of an article, and it's a very lengthy and interesting paper, but I want to just boil down and refer and start at about page 768 of chapter 28 of this longer white paper by the New York University School of Law called the Jailhouse Lawyer's Manual. So basically, the beginning parts of that indicate that, you know, there's Eighth Amendment issues with prisoners. In other words, there's not to be any cruel or unusual punishment, and you know, we can kind of accept that. And this is where there really is a balancing act between, you know, what is cruel, what is unusual, defining terms and so forth. In criminal justice, these things become, there's a practical reality that is involved those. In other words, you look at actual cases and things that people are doing, and you say, well, is this cruel? Is this unusual? You know, and so that's kind of the way that all goes. But in this article, the Jailhouse Lawyer's Manual, I mean, that should tell you something right there. It's almost like they're helping prisoners, you know, assert their rights under different laws. And of course, the Eighth Amendment is always a place to start. And you know, there are many cases where people, in other words, you can see cases where people are not provided basic medical care. It can be cruel and unusual punishment. Not provided with proper housing. Sometimes the prisons and the jails are much too small. They're trying to jam too many people into one cell. That alone can be a big, you know, violation. Some other cruel and unusual punishment kinds of arguments can kind of revolve around solitary confinement, where people are put in cells, never see the light of day. They don't get any exercise. They don't get interact with other people. And so these are some specific things under the Eighth Amendment. But what is really intriguing me is some recent information that I found, and it's in this article and in some other articles, in terms of who is a qualified individual under the Americans with Disabilities Act. And it is an actual fact that there are many cases that say that prisoners in prison have rights under the Americans with Disabilities Act. So I wanted to kind of focus in on this one part. We'll have opportunities to talk about a lot of different things, but I thought you might be intrigued by this and want to look at it. You can just Google on Jailhouse Lawyer's Manual, New York University Law School, and I think you'll find it very fascinating and interesting, and it may be just a little bit more complicated than what you're used to. So You have to take your time. One of the key cases, the thing you need to understand is there's two basic things in this country that have happened since the early 1970s, and that is Section 504 of the Rehabilitation Act, which provides certain rights to people with disabilities, and then the Americans with Disabilities Act that came shortly after that. The Americans with Disabilities Act is the one that's been primarily the focus since it was passed, and it's shown in the books as 42 USC 12132 as amended in 2006. The Rehabilitation Act that I was talking about earlier, which was passed in 1973, like I said, is 29 USC 794, and it was amended in 2007. And so these things are out there. They're affecting cases, they're affecting prisons, they're affecting how we hold prisoners in prisons, how we hold prisoners in jail. First case I want to talk to you about is this case of Pennsylvania Department of Corrections versus Yeskey. That is spelled Yeskey. The full cite to that is 542 United States Reporter 206, and it is 1998 case, and it's one of the first ones to actually say anything about the Americans with Disability Act in prisons. And what it says is that it firmly established that a prisoner is not excluded from being a qualified individual with a disability just because he is in prison. And so that right there, it kind of opened Pandora's box in terms of, oh my goodness, you know, what are these prisons supposed to do with people like this? And the problem where this becomes an issue for us as far as our future is, we have a lot of people in prison for long periods of time on these three strikes laws, habitual offender laws, some of these lengthy gun law violations, some of these lengthy drug violations, and you know, so they're getting like life sentences and so forth. And when they get to be older, they start to get sick, they start to have disabilities, they start to have all kind of problems. And so what the U.S. Supreme Court is saying, based on this Yeskey case, Yeskey versus Pennsylvania, you know, you're going to have to figure out a way to take care of these people in a humane way. And you know, it's just amazing when you think about cases I've seen where there's children being held in caves in Brazil or the Middle East or places like that for small petty crimes that they committed. Well, this case was followed by another case called Onishia, which is spelled O-N-I-S-H-E-A versus Hopper, kind of like Dennis Hopper, H-O-P-P-E-R. And this Onishia versus Hopper is 171 Fed 3rd, 1289 at 1296, and it's a 1999 case. Now the thing about that is it narrows the focus of this ADA down, and it says, what about HIV transmission? What if you got a patient with HIV? What do you got to do with him in the prison population? You know, is he entitled to all these same rights as everybody else? Does he get to eat with everybody else? Does he get to go to the movies with everybody else? Does he get to hang out, as it were, with everybody else? And what they said in that case was, no, the danger of infecting other people is so great that they don't want to put themselves in a position of causing more HIV infections for non-disabled prisoners. That would be an 8th Amendment violation for them. So you're kind of caught between a rock and a hard place. How can you help an HIV patient without endangering all the other prisoners in the prison? So there you go. That's the kind of thing that you get into, is you got to try to find the edges of this whole idea of, you know, what is the right way to handle these different prisoners. And so what they're saying is that they're not going to give any special treatment to HIV patients that allows them to be in the general population because of the potential that they could actually infect other prisoners. So they have to be kept separate in a different type of a facility. Well, here's another case on this. Is a Bullock versus Gomez, like Sandra Bullock, only it's not Sandra Bullock, but it's Bullock versus Gomez. That is 929 Fed Sup, that's F period, SUPP period, 1299. It is a California case. It's a 1996 case. And in that case, they said that prisoners cannot engage in conjugal visits in terms of if they have certain disabilities like tuberculosis or HIV. And so the issue there becomes, what is the level or risk of transmission? Now, this was brought up again in the case of Doe versus Coughlin, 1971, New York 2nd, 48. That's a 1987 case. And here again, the issue was could not attend, an HIV patient could not attend a family reunion because they had to be free of communicable diseases. So here again, can people be allowed to engage in some of these special programs and benefits like conjugal visiting? Now, in the case of Bullock, the way that came out is kind of interesting, because not only did he have HIV, but his wife had HIV. So there was really no harm that would be potential harm to the wife, because the wife already had it. And apparently it was a choice that they made, that they wanted to be together. So basically, the court in that particular case said that it wasn't justified because there was really no danger to her. She already had the disease. So these are where we're trying to weigh this back and forth, and it's, I know that for many of you, you take the attitude that, well, who cares, and, throw them in a hole and throw them a fish head every now and then. But that's just not the way our system operates. Some might say it's become so convoluted that there's no way that it can work. But it is interesting. It's the law. I mean, I'm in this because I have interest in the law. And so, where is this taking us? So in this other case, Spurlock versus Simmons, excuse me, here again, it's another ADA case, and this was needing unlimited access to a TDD phone, and this is a special type of telephone for people with hearing disabilities. So basically what ended up happening was that they had a burden on the prison, because they had to take this deaf prisoner into the special room, unlock the room, put him in the room, supervise him while he's on the telephone, all these different things. And the prison tried to say, well, that's too excessive. We can't spend all that time with them. And so the court said it was okay to have him go and use the phone only 2 times a week and not just on his whim whenever he felt like. And if you had a legitimate reason, like an appeal or something like that, he could probably ask for additional usage, but that he can't just, anytime he feels like it, raise his hand and say, I want to go use the TDD phone, because it is a burden on the prison. So they have to try to find reasonable accommodation, and that means that both sides have to try to be somewhat reasonable in that case. So that was Spurlock versus Simmons. That's a hearing disability case and a special telephone, and the problems with accommodating a prisoner in that type situation. And once again, that website, or the case site, is 88 FedSup 2nd, 1189. It's a Kansas case from 2000. Well, here's another case, and this is a really important one. You ought to write this one down. This is called the Turner test. The Turner test. Turner test. And the Turner test comes from a case called Turner versus Safely. And in Turner versus Safely, it's a 482 U.S. 78 case at 89 through 91. And now this is a 1987 case, and this is the Turner test was created as a reasonable test for courts to apply to prisoners' constitutional challenges on all prison regulations. So this is kind of more of an Eighth Amendment test for any kind of prison regulations, and it's being applied in some cases by courts in ADA and Section 504 claims. And so the question there is, is it reasonable to take a step further from the Eighth Amendment and start applying this Turner test to the cases under the Americans with Disability Act and the 504 cases? So that's an issue right now that's hanging out there in the balance, and we don't know the answer to that. And the Supreme Court really hasn't addressed it. It's interesting, but there's a case called Gates versus Roland. That's a 39 Fed 3rd 1439 case, 1994 case, which says that yes, the Turner test does apply, that you can use this same reasonable test in Section 504 claims, and by implication, ADA claims. And this all had to do with Turner's request, for certain rights. And in the Gates case, he was HIV positive, but he wanted to work in food service. He wanted to work and making meals and serving meals to other people. And the prison argued that it excluded him because of his HIV, because they didn't want anyone else to get HIV from him preparing food and serving food and this type thing. And one of the things that happened is that the courts and everybody kind of took into account, well, what about these phobias and suspicions and the kind of the silliness on HIV where it's like gone overboard? Like in the case of Ryan White, where the school didn't want to allow him to go to school because he had AIDS and was HIV positive. And so basically, they considered all these claims, but they also looked at it using the Turner test, and that Turner test is the right test for these 504 type of claims. And they said that it was necessary in this particular case to discriminate against an HIV positive prisoner and not allow him to serve food or prepare food under any circumstances. Now it's interesting because that's one reaction, that's a lower court reaction to this Turner test. But there's another case that came out just the opposite. That case is called Amos versus Maryland Department of Public Safety and Correctional Services. That case is 178 Fed 3rd 212. It's a Fourth Circuit case, a 1999 case, and basically argued that the Turner test would be inconsistent with the Yeski case that we had mentioned earlier. So let me see if I can find that Yeski again. So basically what they said in this other case, which is Amos versus Maryland, was that Turner test violates the Yeski case, which is Yeski versus Pennsylvania, that we mentioned to you earlier. It's 524 U.S. 206. So basically what we're saying is we still don't know what's the valid test in this kind of a situation. Is it the Turner test? Can it be applied equally to the ADA with the example of the HIV food server? The gentleman had HIV, he's a prisoner in prison, he wants to serve food to other prisoners or prepare food for other prisoners. The court in that case said, no, we're not going to allow that. It could be too dangerous. But is that going to be the final decision on that? I mean, would the Supreme Court come out differently on it? So, hey, look at this. Look at it in the broader context of just, what is the right thing to do with prisoners? And if you get really down to it, you know, if we're splitting hairs over HIV cases and how HIV patients should be handled in prison, you know, there's a lot of other cases that are simple yes cases where we have guys in wheelchairs in prison that are saying that, you know, they're not being handled appropriately, up and down stairs and being strapped in vans and not being safe, being tossed around, knocked out of their wheelchair and things like that. So clearly there is some level of rights for prisoners if they have certain disabilities and so forth. So hey, think this over, look it over, and then let's hear your responses on just, you know, how should we handle prisoners in prison in terms of their rights. Should they give up all their rights and just be treated like slaves, like in some of these movies we see, like Cool Hand Luke and different ones, or should they be given some level of humanity and some level of rights, especially if they have problems like disabilities and this type thing. So think it over. Let us know what you think. Thanks a lot.